This is the Chapter 3, Group 2 report, Recruitment and Placement for Local and Abroad Employment. And my name is Almira D. Kasim from BSBA HRDM 3B. Bureau of Local Employment. Statement of Objectives. It is the policy of the state. Number 1 is to promote and maintain a state of fulfill employment. Number 2, to protect every citizen deserving to work locally or overseas. Number 3, to facilitate a free choice of available employment by persons seeking work. Number 4, to facilitate and regulate the movement of workers in conformity with national interest. Number 5, to regulate the employment of alliance. Number 6, to strengthen the work of public employment. Number 7, to ensure careful selection of Filipino workers for overseas employment. It means that the Bureau of Local Employment aim is to improve the local labor and employment situation in the Philippines. Next, promotion of employment. The Secretary of Labor shall have the power and authority. And as you can see in my report, you will see that number 1 is to organize and establish new employment offices in addition to existing employment office under the Department of Labor as the need arises. Number 2, to organize and establish a nationwide job clearance and information system to inform applicants registering with a particular employment office of job opportunities in other parts of the country as well as opportunities abroad. And next is to develop and organize a program that will facilitate occupational, industrial, and geographical mobility of labor and provide assistance in the relocation of workers from one area to another. And last is to require any person, establishment, organization, or institution to submit such employment information as may be prescribed by the Secretary of Labor. And now we will proceed to the powers and duties. Under the Article 15 of the Labor Code of the Philippines as amended, was modified amended by 797 issued on May 1, 1982, creating the Bureau of Local Employment or BLE with the following powers and duties. That is to formulate policies, standards, and procedures on productive manpower, resources, development, utilization, and allocation. Next is establish and administer the machinery for effective allocation of manpower resources for maximum employment and placement. Number 3, to regulate and supervise private sectors participation in the recruitment and placement of workers locally under such rules, regulation as may issued by the Secretary. Number 4, to establish and maintain a regulation of work permit system to regulate employment of alliance. Number 5, develop and maintain labor market information system in aid of proper manpower and development planning. Number 6 is to formulate employment programs designed to benefit disadvantaged groups and communities. And last, perform such other function as may be provided by law under the Section 3.
Assalamualaikum warahmatullahi ta'ala wabarakatuhu, and good morning to each and everyone, and welcome to my presentation. By the way, I'm Samra Yusuf from BSBA HRM 3B. As you can see on the screen, our topic today is recruitment and placement. Recruitment and placement refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring or pursuing workers, and includes referrals, contract services, promising or advertising for employment locally or abroad, whether for profit or not, provided that any person or entity which in any manner offers or promises for a free employment to 2 or more persons shall be deemed engaged in recruitment and placement. Article 13, Section B, Labor Code as amended. Ang recruitment and placement ay tumutukoy sa anumang pagkilos ng canvassing, pagpalista, pagkokontrata, pagdadala, paggamit, pagkuha o pagkuha ng mga manggagawa at kabilang ang mga referral. Serbisyo ng kontrata, pangako o pag-advertise para sa trabaho sa lokal o sa ibang bansa kung para kumita man o hindi basta ang sinumang tao o entity na sa anumang paraan ang mga alok o mga pangako para sa isang bayad na trabaho sa dalawa o higit pang mga tao ay dapat ituring na nakikibahagi sa pangangalap at paglalagay. Recruitment includes that act of referral or the act of passing along or forwarding of an applicant for employment to a selected employer, placement officers or bureau. People versus Saleh 291 SCRA 715. The number of persons dealt with not an essential ingredient of the act of recruitment and placement of workers. The provision merely creates a presumption. People versus Panis GR number L 5867477 July 17, 1986. Kasama sa recruitment ang pagkilos na iyon ng referral o ang pagkilos ng pag-asa o pagpapasa ng isang aplikante para sa trabaho sa isang napiling employer. Ang bilang ng taong nakipag-ugnayan ay hindi isang mahalagang sangkop ng pagkilos ng pangangalap at paglalagay ng mga manggagawa. Ang probisyon ay lumilikha lamang ng isang pagpapalagay. Private Fee Charging Employment Agency. Private Fee Charging Employment Agency means any person or entity engaged in the recruitment and placement of workers for a fee which is charged, directly or indirectly, from the workers or employers or both. Article 13, Section C, Labor Code as amended. Ito naman sa Private Fee Charging Employment Agency ay naniningil ng bayad ay nangangahulugang sinumang tao o entidad na nakikibahagi sa pangangalap at paglalagay ng mga manggagawa para sa isang bayad na sinisingil, direkta o hindi direkta mula sa mga manggawa o employer o pareho. License. License means a document issued by the Department of Labor authorizing a person or entity to operate a private employment agency. Article 12, Section D, Labor Code as amended. Dito naman sa license, ang ibig sabihin ng lisensya ay isang dokumentong inisyu ng Department of Labor na nagpapahintulot sa isang tao o entity na magpatakbo ng isang pribadong ahensya sa pagtatrabaho. In private recruitment entity means any person or an association engaged in the recruitment and placement or worker locally or overseas without charging directly or indirectly any fee from the workers or employers. Article 13, Section E, Labor Code as amended. Sa private recruitment entity naman is recruitment entity ay nangangahulugang sinumang tao o isang asosasyon na nakikibahagi sa recruitment and placement o manggawa sa lokal o sa ibang bansa, nang hindi naniningil, direkta or hindi direktang anumang bayad mula sa mga manggagawa o employer. Authority. Authority means a document issued by the Department of Labor authorizing a person or association to engage in and placement activities of private recruitment entity. Article 13, Section F, Labor Code as amended. Sa authority naman, ang autoridad ay nangangahulugan ng isang dokumento na inisyo ng kagawaran ng paggawa na nag-autorisa sa isang tao o asosasyon na magsagawa at maglagay ng mga aktibidad sa isang pribadong recruitment entity.
Assalamualaikum warahmatullahi wabarakatuh. I am Alma Amar and this is my assigned topic, which is illegal recruitment for local employment. Article 38 of the Labor Code as amended providing for illegal recruitment is termed confined for local employment since as regards the overseas. The illegal recruitment is provided in Section 7 RA 8042, otherwise known as the Migrant Workers and Overseas Filipinos Act of 1995. One of the reasons kung bakit Filipino hired illegally is because sometimes they're not qualified. They might have been rejected from another jobs. And when they in need, they take any job they can get. Ang pinaka-common na example ng illegal recruitment is fake recruitment scam. Employment of non-resident alien. All foreign nationals seeking gainful employment in the Philippines or their prospective employers shall file their application with the Dole Regional Office having a jurisdiction over the intended place of work. The requirements of the foreigners or non-resident aliens are required to obtain an alien employment permit prior to work in the Philippines. They are prohibited from transferring employment without prior approval from the DOLE Secretary. According to the Section 5 DO 14615, the applicant shall pay of 9,000 para sa permit valid for 1 year and 4,000 para naman sa every additional year. Grounds upon which permit must be issued. Alien Employment Permit or AEP shall be issued based on the following grounds. Number 1, compliance by the applicant employer or the foreign national with the substantive and documentary requirements. Number 2, determination by the DOLE Secretary that there is no Filipino national who is competent, able, and willing to do the job for which the service of the applicant are desired. And number 3, assessment by the DOLE Secretary that the employment of the foreign national will redound to the national benefit.
Assalamualaikum, my name is Rinad Abbas. Permit issued shall be valid for a multiple employment. The permits of resident foreign nationals shall be valid for a multiple employment regardless of the nature and duration of their employment. Report changes in their employer status and the identity of their employers to the Dole Regional Office, which has issued the permit 74 Rule 11 Department Order Number 7 Series of 2000. The permit issue of resident foreign national ay may visa para sa marami or maramihang trabaho, anuman ang uri at tagal ng trabaho. Pero kailangan nilang mag-provide ng any changes ng status ng employee and identity nila. Halimbawa, kung ang employee ay na-promote, kailangan nilang i-report ito sa DOLE. Revocation or cancellation of the alien employment. Number 1 is mispresentation of facts or falsification of documents submitted, o yung maling paglalahad ng mga katotohanan o falsifikasyon ng dokumento na isinumite. Number 2 is the foreign national has been declared as undesirable, o yung mga foreign na pumupunta sa ibang bansa na ang pakay ay gumawa ng illegal na gawain. Number 3 is non-compliance with the condition o ang hindi pagsunod sa kondisyon na inilabas ng AAP. Number 4 is failure for renew AAP within 1 year o pagkabigo sa pag-renew ng AAP sa loob ng 1 taon pagkatapos ito ma-expire. Philippine Overseas Employment Administration Seaman Article 13G Labor Code as amended. Seaman means any person employed in a vessel engaged in maritime navigation, and overseas employees or employment of a worker outside the Philippines Article 13 Labor Code as amended. It is an employment of a worker outside the Philippines covered by a valid contract of Philippine Overseas Employment Administration, rules and regulations governing the recruitment and employment of land-based overseas worker, Feb 2, 2004. Immigrant means any person, worker, or other who immigrates to a foreign country by virtue of an immigration visa or resident permit or its equivalent in the country or destination. Article 13 I Labor Code as amended. Immigrant, ito yung mga tao na nag-move out sa kanilang place to live in another country permanently. For example, people move in to search work on economic opportunities, to join family, or to study. No private employment agency, except as provided by law, no person or identity other than the public employment offices, except as provided by the law, no person entity maliban sa public employment offices ang dapat magkisali sa recruitment and placement ng mga manggagawa. Article 16, Labor Code as amended.
Philippine Overseas Employment Administration or POEA. Philippine Overseas Employment Administration, a POEA, was created by Executive Order Number 797 issued on May 1, 1987, thus modifying Art 17 of the Labor Code as amended. Ano nga ba ang POEA? Isang ahensya ng gobyerno ng Pilipinas na responsible sa pagbubukas ng mga benepisyo ng programa sa pagtatrabaho sa ibang bansa. Ito ang pangunahing ahensya ng gobyerno na itinalaga upang subaybayan at pangasiwaan ang mga ahensya ng recruitment at money sa ibang bansa sa Pilipinas. Well, the function of POEA are provided by Executive Order Number 247 issued on July 27, 1987 as follows. Number 1, regulate private sector participation in the recruitment and overseas placement of workers by setting up a licensing and regulation system. I-regulate ang participation ng pribadong sektor sa recruitment at paglalagay sa ibang bansa ng mga manggagawa sa pamamagitan ng pag-set up ng sistema ng paglilisensya at regulation. Number 2, formulate an employment in coordination with appropriate entities concerned. When necessary, a system for promoting and monitoring the overseas employment Filipino worker taking into consideration their welfare and the domestic manpower requirements. So si POEA ay minomonitor niya yung Filipino na nagtatrabaho sa ibang bansa at yung at ipagtataguyod at pagsusubaybay sa trabaho sa ibang bansa ng mga manggagawang Pilipino na isinasaalang-alang ang mga kanilang kapakanan at mga pangangailangan. Number 3, protect the rights of the Filipino worker for overseas employment to fair and equitable recruitment and employment practices and ensure their welfare. Si POEA pinoprotektaan ang mga karapatan ng mga manggagawang Filipino para sa pagtatrabaho sa ibang bansa sa patas ng mga kasanayan sa pangangalap ng trabaho at tiyakin ang kanilang kapakanan. Number 4, exercise original and exclusive jurisdiction to hear and decided violation of the condition of issuance of licensed authority recruitment workers. Gumagamit ng original at eksklusibong jurisdiction upang marinig at mapagpasyaan ang paglabag sa mga kondisyon para sa pag-i-issue ng lisensya o otoridad ng mga recruit ng mga manggagawa. Banner direct hiring. No employer may hire a Filipino worker for overseas employment except through the POEA entitled authorized by the Secretary of Labor. So, hindi pwede si employer na mag-hire ng Pilipino na magtatrabaho sa ibang bansa. Dapat ay na hindi dumadaan kani POEA. Direct hiring by members of the diplomatic corporation, international organization, and such another employer as may be allowed by the Secretary of Labor accepted from his provision. Art 18 Labor Code as amended.